Welcome, welcome back. Today we're going to talk about something that is near and dear to every bar exam taker's heart, or perhaps is the bane of their existence. I'm talking about the essays on the bar exam. And this is something I've wanted to talk about for a while because it flies under the radar when it comes to doing well in the essays. It's what I'm calling here the inverted pyramid of the bar exam. And what does that mean? There might be certain assumptions you've had about the exam or the essays that may actually be the other way around. Let me show you what I mean. So let's go back to law school for a little bit. Let's go back to your impressionable days in 1L, 2L, 3L. You had one final exam per subject, different professors. And each of these professors you may have had to study because they had different preferences, they had different things that they wanted to emphasize. And then you wrote these beautiful essays, this prose, 8 pages of just creative, uh, wordy, whatever creative writing exercise, and you have all this like analysis coming from all angles, and you're so proud of it. You want a copy for yourself so you can frame it. And you probably did for your first exam too. And then now compare that to the bar exam. It is, it's reasonable that you'll think that it's somewhat similar because the bar exam is pretty much a mega final exam, just with multiple subjects, and they're tested it as essays, different forms like the multiple choice, performance test. There are way too many rules to know, so it is understandable that bar exam takers are very focused on memorizing, the rules and just basically juggling everything in their head. There are some differences here too, and some of this might be good news after I've raised everyone's anxiety. There's one client, so to say, or the grader, and they have predictable needs pretty much because they are calibrated with different graders, and they are probably given a rubric, and they are probably, theoretically should be grading every exam, every essay the same way. But maybe there's a little variation, but there is some predictability. There is some way that to help them along with the grading process. So at least with the essays, the focus is a little bit different. Instead of having these huge, 1.5, 2 hour, 3 hour essays, you have 30 minutes or an hour where you have to kind of show your knowledge within that short period of time. And the focus of that, the focus of issues is, of course, IRAC. You've heard of it. It includes issue, rule, analysis, and conclusion. And this seems like a pretty fair representation of what IRAC is. You have these 4 components. They're all important, and that is true. They are all important. And you think about it a little bit more. You think about that food pyramid from the USDA. You have dairy in one corner, and bread and whatnot. So you think about it like this, maybe. You have your issue, and then under that you have this all-important rule. You're so focused on memorizing it, you slam it out of the park. You got the rule down, and then you have this beautiful paragraph, this 1 page long block of text, this wall of prose that you call the analysis, and you're so proud of it. It took you about 20 minutes to type up, and then you come to this grand conclusion. You did all this analysis. You are so confident that this is the conclusion. This is another way to look at it. You have this container of IRAC. You have this package where you start with the issue, and then within that package you have the rule, you have the application, you have the conclusion. It's all very nested nicely and neatly. But here's where I want to deviate a little bit. In fact, it's actually the other way around. I think the issue is actually the most important, the key of every essay or every IRAC. And then after that, everything else sort of cascades down. You have, once you set up the issue correctly, everything else just sort of naturally falls down. You know the corresponding rule because you've spent so much time trying to remember it. And then you have the facts in front of you. It's typically 1 page, so you can pull out some facts. You can stick in the relevant facts, match it with the corresponding rule, and then you come to a conclusion. just like the real USDA food pyramid, we have sort of switched up what we thought was important. Um, and then now we have this. I mean, I don't know if this is confusing at this point, but let me move on here. And the application, this just to show that the application can have multiple mini IRACs in there. You have the sub issue, sub rule, sub application. So this is one mini IRAC, and then this is one IRAC unit for an issue. So what am I trying to say here? I want you to kind of step back from what you learned in law school. I know it's been 3 years of indoctrination and institutionalization. I want you to think of the bar exam as a new skill that you have to learn. Think of yourself as a fresh first year. You are a first time taker. You know nothing about the bar exam, or if you are a repeater, then you know a lot about the bar exam. You kind of have an idea what the graders might be looking for because you've looked at the sample answers and whatnot. But in this video, I want to emphasize that the issues are the real key to essays. If you don't have the issues set up correctly, without the issue, you have no IRAC in the first place, which means you are leaving points on the table. And every point counts on the bar exam. The curve is rather tight, and let's say you miss a couple of points here, a couple of points over there, and soon you are, becoming a repeater like me. So, I want you to grab as many points as possible. And the other thing that's different about the bar exam with the essays is that the graders don't really have time to read them. Unlike your professors who, it's their job, they get paid well. But I've heard stories about graders who read these essays at the red light while they're driving with a pile of boxes. They have 1,000 essays to read, and they only get a few bucks per essay graded. And then I've also heard of people reading these essays on the toilet. So when you get your essays back, just be careful with that. But these graders are possibly skimming through them. They don't have time to read your masterpiece, and so you want to be able to communicate to the grader that you know what you're talking about. I want to deviate a little bit here as to why I failed the bar exam the first time. I took the California bar exam in 2013. I failed it, and then on my second try in 2014, I passed. And I learned a lot of things in between those two attempts. I've tried different things. I've tried different strategies. I kind of went off the beaten path of what Kaplan told me. And one of the reasons that I failed the first time was because I fixated too much on rules and theory. And then I was doing everything by the book. I was doing what the course was telling me to do. I consumed everything that they were giving me, which was more exhausting and definitely less exciting than tinkering around trying to solve past exam questions. People look for motivation. They look towards the sky, waiting for motivation to drop. But if you're just waiting for it, you're gonna have a good view of the clouds for a while. I was, this was not very exciting because I was watching all the lectures very diligently. I was filling in the blanks in the accompanying course workbook, and this process took 6 hours, 8 hours, and I would just be exhausted after all that. I didn't have time to do anything else, let alone, put in the mental effort to solve past exam questions until it was like 2 weeks before the exam. I was checking off the assignments. I gotta make sure everything is complete. I gotta complete this. I gotta fill in this percentage meter. It's taunting me, 70%. I want 90%. I want 100%. But the point of preparation is not to complete the course. It's not to transcribe these expensive video lectures. The point is for you to use the course. It is just a part of your arsenal. You have to use it to learn. The point of preparation is to prepare, is to do what's going to help you learn. You are not serving them. They are supposed to help you. They are there for your support. And you may also feel this sense of security when everything is so structured and they have it laid out for you. It's like your parents deciding on when you're gonna get married, when you're gonna get your first job, and so on. But you don't have to follow the plan. Just because they planned it out for you. And besides, these courses, they have schedules that are exactly the same for someone who is a 20-something person, living in their parents' room. They don't have a job. It's their full-time job. Their full-time job is to study for the bar exam. That schedule is exact same as someone who has a job, someone who has families to take care of, someone who has some other issues. Their parents, their kids. It doesn't make sense that this one cookie cutter plan is something that you need to follow. That is, you want to be very, uh, you want to be very conscious about how you use what they give you. Again, the bar review course is just one piece of your arsenal. You don't have to do exactly what they tell you. Everything that they give you is just a mere suggestion. So I would like to, I'm kind of going off tangent here. Um, yeah, after I failed the first time, I felt so smug coming out of the exam room. I didn't know what I didn't know. Merely memorizing the rules gave me this dangerous and fake sense of security. When knowing the rules it just turned out to be minimum. It was just a minimum requirement, just table stakes. Everyone was doing it. It is just a cost of admission. So I passed when I relaxed. I took things into my own hands, and I used strategies that helped me learn. It was not about finishing watching the lectures for just completionist sake. And I basically enjoy the process, and hopefully I can encourage you to do the same. All right, going back to IRAC. So that was a problem, but what should you actually do? And the other thing that I want to emphasize is that knowing the rules is different from knowing how to use the rules. And part of that is knowing the issues as well. These big bar review courses focus very heavily on what to learn. They have these, and their outlines are actually quite good. They're great, but the courses don't really focus on how to learn, how to use those resources. They just give you all this massive information, and they assume that you know how to use it. They give you the tools, but not the instruction manual. And here I want to provide some of that how-to information. And part of that is letting you know that the issues are the real key to essays. Don't get too distracted by the rules and the obsession of needing to memorize and you'll be okay. Just that line of thinking. Just because you know the rules, again, doesn't mean you know how to use the rules. And I talk about a couple of techniques that are popular with my readers. One of these is issue checking, which I'll be talking about in this video. You can Google essay cooking and then essay cooking bar exam or something, and then you can read more about it. And this video just focuses on the essay part. The MBE is outside the scope, and so is the PT. But just as a fair notice, it is also a big part of your score. And it is very easy to neglect because the MBE, the essays, they take up so much space. They take so much memorization. So, but I don't want you to later on regret it like some people do. It's a very common regret. They think that, I could have gotten a few more points on the PT and then they would have passed. And that's not a good place to be in. So let me go through an example here where we are going to focus on these different parts of IRAC, but we're not going to have this huge analysis, so to say. So first of all, the issue is very well stated. It's underlined, it's bold, it's very clear. Is punching the grader right in the eyes. This is a very simple, of course, torts example, but in different, more complicated topics like hearsay, for example, you may have many different exceptions to hearsay. You want to be able to tell the grader that I identified all these different exceptions and whatnot. And next we have the rule, of course, our favorite part. And here we have a few elements here. We have harmful or offensive contact with the plaintiff's person. There's intent. There's causation. And here's just a little bit more exposition as to what someone's person means. And this is not strictly necessary. It depends on what the facts are really talking about. If it's unclear whether, let's say the plaintiff had a purse on, That is an extension of the person. So if the defendant has some sort of physical interaction with the purse, then this is a relevant rule to kind of stick in. And here we have some sub-issues based on the elements. We have harmful or offensive contact. That was one of the elements. We had intent. We had causation. If you have some minor elements, it's okay to combine them. It's if the main part here, typically for torts battery, the main part is whether there was offensive contact with the person. So this is going to be the focus of this answer and this example. So this is the sub issue, and another common mistake that some students make is that they lay out this nice rule here for battery, but then they don't really go into what this rule element means. They think that you are done just by having this, and then they end up with a mediocre score. I see this very often. So here I have an example rule statement about what harmful or offensive contact actually means, what the standard is. So we have that requires harmful or offensive contact with P's person, where P's person includes the person or the body or something closely connected to that person, such as a purse. There must be a direct physical contact that would be offensive to a reasonable person. So that is the standard for what is offensive contact. And this is also part of the intuition you can gain from trying on multiple essays that have similar issues. So that's another reason that you want to look at past exam questions rather than just memorizing the words. Just because you know the words on a page doesn't mean your body knows what to do with those words. So you want to be learning from example, and that will also contribute heavily to your memorization, because if you understand something, it's easier for your brain to accept it. And this is just an example of application. You can pause the video to read what I wrote. But here I've bolded some key terms here. We have the word here. You could say in this case or something similar like that. That is an indicator that you are starting the application. You are going to talk about this particular case. I used the word because here to connect the rule to the fact. It's a nice, simple word. It helps you kind of check off that you've used the rule element or the facts. And there's also a study about the word because. It increases the convincing nature of what you're saying. And we have this conclusion. Thus, defendant made harmful or offensive contact because smoke in the plaintiff's face was blah blah blah. I like to recommend that you give a short summary of the argument. It's not necessarily required, but I think it's a nice way to kind of tie up and kind of, at least for your own kind of organization of what's going on. But you'll notice that without the seed that was the issue, you aren't able to discuss these things in the first place. Let's say you didn't bring up this sub-issue. What is harmful or offensive contact? Let's say you just had this, and then you had just one application paragraph, and then you concluded, and you thought that was one IRAC. That is one IRAC, but you are leaving points on the table if you are not identifying these smaller sub-issues. And other examples of sub-issues are expansions of what the issue is, like nuances. Sometimes you have exceptions. Sometimes you have sub elements like this. Sometimes you have defenses. Defenses are very important. So now that you know that issues are key, now that you know that they're even more important than rules or analysis, they're all important, of course, but issues are, again, the inverted pyramid. They are the most important if we had to rank them. If you want the points, how do you even go about doing this? Is there a way to do it? Well, you could just go ahead and begin spotting issues like they told you in law school and bar review courses, or this particular blog article I screenshotted this from. You can, just try your best. See if you can spot as many issues as you can. Cool. Well, I don't know. Maybe there's a better way. Let me show you how. What we're used to is issue spotting. Ever since law school, they say, to spot the issues, you ask a first year law student, how do you answer an essay? And they're going to say, oh, issue spotting. Unless you're pretty knowledgeable about the subject, just issue spotting can be a risky approach. You just happen to recognize these issues. It's it's good enough for major issues because you'll recognize them out of familiarity. That looks like a negligence issue. Great. That's definitely a homicide. Someone died. Okay. Or sometimes the question just tells you by asking, for example, if the defendant could be guilty of robbery. And that's fine. But what about the finer issues? The essay, the issue identification is about identifying these smaller nuances if you want to get the points. The sub-issues, the exceptions, defenses, etc. Well, if you're issue spotting, you're sort of leaving it to chance. You're just kind of saying you'll know it when you see it. Now, contrast that with issue checking. It's a more methodical, systematic approach where you can be tested in all these issues. Now you want to match the facts to these issues, these pre-existing issues that can be tested. Just like there are fact patterns, there are fact issue patterns as well. For example, in every subject, there are some things that you want to always bring up. For contracts, it's applicable law, whether this situation falls under the common law or UCC. Or let's say in an evidence essay, you're evaluating whether a piece of evidence is admissible. You always want to talk about logical relevance and legal relevance. That's a pair of issues that you want to bring up. Those are some examples of issue patterns. And just having all this, testable material, these issue patterns, first, these things to know first. Having that information and going through that, just like a checklist approach, is a more reliable way to make sure that you scrape all the issues out of an essay and get, scrape all the points off the essay. If airplane pilots use a checklist before takeoff, then why don't we also do that to ensure that we're scraping all the points off the essay? For example, again, if you're more likely to remember to bring up defenses, that will definitely add to your points. And by the way to counter argue in an essay is not to bring up these different hypothetical arguments. You'll sometimes see people saying plaintiff will argue this, and then defendant will say no, that's not true. They're gonna assume these things, and then the plaintiff will win because the defendant was pulling arguments out of his ass, whatever. But the better way to counter argue is to bring up legal theories instead of making up hypothetical arguments by each party. So if we go back to the torts example, battery, that theory of battery is something that the plaintiff's going to bring up, and then the defendant might say maybe there was I don't know, maybe there's a hockey game or something. Well, I don't have my rules in front of me, but let's say negligence. Someone's bringing up negligence, and then the defendant says, there was contributory negligence from the plaintiff too, or there was assumption of risk. These are legal theories. Like, these are actual headings that you could put under. The more headings you have, the more issues you have, the more points you're going to get. Now, how do you issue check? You could create a list of testable issues. That's what you want to have, a list of testable issues. You want to be aware of those issues. And you could create that by, for example, looking at the NCBE subject matter outline. It clearly tells you what is testable. You could look at some bar review outlines from Barbary, for example. You could look at the headings there, the table of contents. You could go through past exam essays. You could pull out what's been mentioned in the model answers. You could also I also have some checklists and flowcharts prepared already. They're called APRA sheets, and each checklist, each flowchart is a one-pager that groups issues according to the facts in an if this then that fashion. I took past essays, I took past MEEs, like secure transactions, to make sense of the patterns of issues. For the more visually oriented, there's a page with a flow of what to check for next. And I'll show you some examples here. Here is a contracts APR sheets. So we have first things to check. I mentioned this before. You always want to check for the applicable law, whether it falls under UCC or common law. And if it is UCC, whether the party is a merchant also comes into play. And depending on the facts of the essays, you can consider all these different issues. So this is a checklist, and this is a flowchart that kind of clumps these flows for each major issue. And let's see here, torts. So here again, depending on what the facts are talking about, we can consider these different different issues depending on what the facts are saying. If something happened, then you want to talk about these things, and of course you want to consider defenses, all these defenses that could be brought up. Of course, you have flowcharts as well. And depending on the nature of the subject, these flowcharts are not exactly flowcharts. They're again a rearranged checklist. But let's see if there's another one I can show you. Let's see. How about evidence? That's a good one. So this is a California example. So this will be missing in the UBE edition, but logical relevance, legal relevance. So here's a flow of whether a piece of evidence is admissible. Go through this, and then depending on how it comes out, is it hearsay? No, yes. How about this one? How about secure transactions, everyone's favorite? So again, first things to check, different situations that could arise, and a flowchart. And if you want more samples and information, I left the description, a link in the description, so you can check that out as well. Okay, so finally, what are some takeaways here? Consider what is different on the bar exam. It's not the same as law school. The essays are shorter. The professors don't really read through it as carefully. You want to consider the inverted IRAC pyramid, where the issues are the most key. So you got to make sure to get the issues down. That is the most reliable way to get the most points in the essays. Make sure the grader knows that you have identified these issues, underline them, bold them, do whatever it takes to punch the graders in the eyes. And to do this, consider a systematic approach like issue checking over randomly spotting issues. And there's different ways to do it, but I offer APR sheets to kind of have this prepackaged sort of checklist and flowchart. So hopefully this made you think about essays in a little bit different way. I know for first timers especially, it can be very overwhelming to face this. It's a completely different kind of project compared to what you've gotten used to over the past 3 years of law school. So hopefully this was helpful. Let me know if you have any questions down in the comments.